So we'll now start, and then, if people come in, then that's great. So my name is Nicholas Leblanc, and I'm here to kind of give you guys a presentation on wills and estates. So we've done several of these over the past year, at least a couple. Our goal is to continue to give presentations to members of the public. It's primarily targeted to those of you that work directly with members of the public and that may have to field questions from community members, and they may not necessarily know where to turn, and that you're the best resource for them, so that they may ask you questions that you may not necessarily have the information to give them. So the goal is to be able to provide you all with the opportunity to learn more about different areas of law, and in this case, wills and estates. The presentation through PowerPoint will be sent out afterwards, as well as the recording, I believe. So if some of you need to step out, I will try to stay within the hour and 15 minutes. I do tend to talk maybe a bit much, so please feel free to, if you do need to step out, and you want to catch up on it, we will be providing that afterwards to the participants and those that would like one. I also encourage any questions to be asked. I may not be able to see it as clearly. I seem to have been having confusions with my dual screen here. So Kelly, who's the moderator, who's assisting me, will hopefully be able to catch any questions and direct them to me. But just to let you guys know that please feel free to interrupt me or to ask a question, even if it's something that I may get to later on. I'll be happy to ask or answer the questions that come as it comes to your mind. So in terms of myself, so I'm a public legal educator at the Legal Information Society. So essentially my role, although I'm trained to be a lawyer, I practiced for a while. Now I provide legal education to members of the public, and through LISNS, the way that we typically provide that is by way of our phone line, the legal information line, by emails that we may receive, and by live chat that is available through our website, more on an ad hoc, more on a, when we have a staff member who's available to field the questions through live chat. And of course, our website that is on the screen. So encourage anyone to ask questions. If there's anything particular about the presentation that you wish to ask, certainly encourage you to use my email of Nicholas@legalinfo. But of course, if it's a question pertaining to an area of law, a personal question, or you want to give it to a member of the public, it would certainly be much better to send it to questions at, so that we have multiple people that look at that email address to answer those questions. So I'm just going to, on this resource page, there's a few links, and hopefully this will work in terms of being able to see it, and yes, I guess it can. So this is the government's document, which is called After the Loss of a Loved One. It is a document that was created a few years ago, or at least updated a few years ago. I think it's existed. It used to be called the Butterfly Handbook, I believe. In any event, it's a guide that is aimed to assisting people on issues surrounding dealing with an estate, more in the emotional, practical sense. So it's not to confuse the issues surrounding court and the issues that everyone may need to deal with when losing a loved one. So this guide is a useful tool to use. There's also a section on our website that deals specifically with, we'll see if this works, but deals specifically with the issues surrounding wills and estates, and it will also deal with other issues such as vulnerable adults. We kind of include those issues. So estate, when we mean an estate in law, usually means managing someone else's affairs, but that could be because the person has died, as well as the person is alive but has lost capacity or competency, and therefore they're not able to manage their own affairs. So that's why we use that word wills and estates. Estates is, it can be about someone who is alive as well as someone who has passed away. So this section of our website will go over things. So that's just a direct link. And then the court has information on their website that is geared for people, members of the public, to be able to review. More specifically, there's a section on a list of resources for people that, well, this page itself in the court's website is for representing yourself in all matters, whether it's in family court, which is often one where people may have to attend court on their own. Small claims court is another one where a lot of people will self-represent. And then, of course, in the probate court. So probate court does provide guides that are meant to be accessible and digestible by members of the public without any legal training, just to kind of provide a bit more detail as to what the probate court does and how to access it. There's also information that I think is important for people to know surrounding what the government of Canada provides in terms of a death benefit. So for those of you that are not aware, anyone who contributes to the Canada Pension Plan for at least 3 years, then they will most likely be able to receive the CPP. Sorry, 10 years. 3 years is the. But as long as you work, you're usually going to be contributing to Canada Pension Plan, and upon death, then a person can receive the death benefit, which is a one-time $2,500 payment, more or less, to $2,500 to pay for or offset, I should say, the cost of a funeral, and that can be applied for by any next of kin. So it's important to kind of distinguish a next of kin that the government may accept and an executor or an administrator, terms that we'll get to in a minute. But this is simply dealing with government. And of course, when a close family member has passed away, or a friend, or someone that we are responsible, or we feel a certain responsibility to manage their affairs, well, then that person can apply for the death benefit, or they can get assistance with applying for the death benefit through the funeral home. They will be able to assist the person typically. So when you have a funeral director, they will be able to assist with that. And occasionally, for those that lose a spouse, typically, or if a dependent child loses a parent, and then there would be a survivor pension. Again, these are things that fall just out of the legal system, if you will, from the courts. It's not about a will or the courts or things of that nature. It's really just the federal government, through our Canada Pension Plan, will be able to provide certain financial aid to a person, a family member who's eligible. So these are going to be usually a person who has been legally married or was in a common law relationship with the person when they died. It's important to know as well that this legally married, that doesn't mean that you are still together. If you don't have a divorce, then you are legally married. If you are separated but still legally married, then you're still legally married to the deceased CPP contributor. So there are times where it may be the legal spouse who applies for it, even though they may have been separated for quite some time. So those are the reliefs or remedies that the government will provide to people. So I just wanted to highlight those. And the focus of my presentation is primarily going to be on issues after death. However, there is oftentimes confusion surrounding the moments leading up to death and what may happen in terms of consent to hospital treatment or things of that nature. So I just wanted to touch upon this, although I think that kind of when I was going through the presentation and creating the slides, I realized that it would most likely be beneficial to create a webinar in the future in 2022 that will deal with more of these issues surrounding consent to treatment and things of that nature of an estate when a person is still alive, but prior to their death. Because obviously, with an aging population, we end up having people that may fall ill and may live for much longer than they may have in the past. So these questions are obviously going to be relevant to a lot of people. But I just at least wanted to touch upon this briefly. So oftentimes people get confused, especially with what has happened with COVID and the restrictions that may come in with respect to gaining access to a hospital or a long-term care facility, and as who is ultimately able to make these decisions. Well, this was always found in the law, and always is a relative term, but this is not post-COVID. This is all been in place for many, many years. Is that the doctor or the medical doctor, the physician, the attending physician, will determine whether a patient is capable, has capacity to make medical decisions. And if they do not have capacity, then they can create or rather sign a Form 1 document that is at their disposal, and basically say the patient has lost capacity and can no longer consent to treatment. So then therefore, who is going to be the next in line, that what we call the substitute decision maker? So it gives you a list of the people that are to be next in line. So when we're talking about a next of kin, well, really what it is a substitute decision maker. And the first one that they'll refer to is the person that has been named under a personal directive. They refer to a Medical Consent Act. That was the old, prior to 2010, we used to have something called the Medical Consent Act. That was replaced by the Personal Directives Act to be a bit more modern, if you will, in terms of the requirements of the vulnerable adult who may no longer just be saying, well, I want you to consent to treatment A or treatment B, but rather I may be in a long-term care facility for years, and this is the type of personal care I may wish. So who is given that authority to make those decisions? Well, it can be the person named in the personal directive, if one exists. So that's the first one. And then, of course, the second one, which is pretty common in an order of priority, is the court. The court can always kind of elevate someone out of that. But then it goes to more the common, we'll say, situation of, you don't have a personal directive, it doesn't get litigated through court. So, well, who it is, who is the registered nurse or the doctor, who are they turning to, or the social worker? Well, it's the spouse of the patient, if they are there. If they don't have a surviving spouse, then it'll go to the adult child of the patient, and on it goes. The parent, person who stands in local parentis, that's essentially, think of that as a step parent. And it continues to go down the list, but these are or statements. So it's not and, it's not a sharing of the role between the spouse and the child, it's or. So if the spouse is there, the spouse is the designated person. If there's an adult child, then it's the adult child that decides, not the parent of the patient. So, mother and son, mother of the patient and son of the patient are in disagreement. Well, it's the son that decides. And of course, it can be a situation where you have multiple people that are of equal standing. Well, at that point, there's no compromise. If they cannot agree, then courts would have to decide. And that's where you end up with this, appointed by a court of competent jurisdiction. But that's where maybe the personal directive can be extremely useful for some people, is to, if they feel, well, you know what, my two children are not going to be able to agree, so I need to elevate one because I can't have them fighting over me when and create conflict. So that may be a situation where the patient may wish to have a personal directive, but it needs to be made when you have capacity. It is a document that you create when you have the ability to consent to treatment. Once you lose that capacity and you have not written it, then it is not something that you can do. So it cannot be, well, but dad told me that, or mom told me that, or son, or whatever. It needs to be something that is created and that it can be followed under the personal directive. So in this order of priority, just as I said, kind of goes down all the way at the end is the public trustee, which is ultimately read government, right? So that's just government that would take over, but that would be at a last resort. The personal directive is just to kind of, again, say what it is. It doesn't require a lawyer to have it. A lot of people get confused, and we'll get to that in a minute, with other documents, that there's this assumption that these documents require a lawyer to sign off or to oppose their stamp or something to make it legal. Well, lawyers do not have authority other than what is given to them through either courts or through a law. They usually have more question of, they have the information, they have the knowledge or experience. The example I will give oftentimes when I'm talking to people on the line is, I don't need a plumber or an electrician to do work around the house. There is no legal requirement. My wife would most likely much rather I have a plumber do work around the house, because I am not a very handy person. But that doesn't mean I can't do it. I may not do it as professionally or as well as a carpenter or whoever else, contractor that I may hire, but that comes at a cost, and I may not wish to do that. And I have friends that are much more handy than I am and would be much more comfortable doing it. It's the same thing with the law. So there are situations where we all have our different strengths and weaknesses, and maybe some people feel much more comfortable having a lawyer prepare documents for them, that they will feel more comfortable, that it will be respected by other people. But there is no legal requirement to have a lawyer sign this personal directive, for example. It simply requires a witness. And what I mean by a witness is not, again, a lawyer, but rather a person who is not going to be the person who's going to have the authority, or the spouse of the person who's going to have that authority, what we call a delegate. So the delegate is the person that, the substitute decision maker. That delegate, well, they can't be the witness because, well, maybe there was influence, undue influence or pressure. It can't be the spouse because, well, really, it's one and the same sometimes. So they, as long as the witness is anyone over the age of majority, which is 19 in Nova Scotia, then they can act as a witness. There's no problem. People will oftentimes confuse powers of attorney, or a power of attorney, and a personal directive. And this is not uncommon, where even members of the hospital team may start saying, well, do you have a power of attorney? Well, there is no power of attorney when you're dealing with medical issues. You're dealing with financial questions when you're dealing with the powers of attorney. That is to give a person the authority to enter into financial relationships, typically contracts, and basically duplicating our own personal authority to enter into contracts for ourselves and giving it to someone else. So if I have a situation where I have a power of attorney and a personal directive, well, it's the personal directive that deals with medical decisions. The power of attorney deals with financial decisions. So and a power of attorney typically is just going to be an ordinary power of attorney. And what that means is, we often think of a power of attorney as a person who has a lost capacity and therefore cannot make decisions. But think of any time you go to H&R Block to file your income taxes, or go over to motor vehicle and they ask for permission from the other registered owner of the vehicle. All of these things is, if you're giving that authority to someone else to act in your name, that's ultimately what you're doing. You're designating or authorizing someone to act in your name. So a power of attorney is a more broad document that essentially allows a person to say, okay, well, go buy land for me in New Brunswick, which is, if I have a sister out there, I don't want to travel to New Brunswick to buy a cottage. Well, I can create a power of attorney and say, hey, sister, sign off the paperwork for me. But that doesn't mean I want her to, if I become incapable or incompetent, to start managing my financial affairs. I'd much rather my wife do that. So that power of attorney, an ordinary power of attorney, would end or cease when I lose capacity, when I lose the ability to make decisions for myself, and so does the attorney. And the attorney is not in the American term. We don't use attorney as the Americans do. That's a lawyer or a barrister, I guess, but we usually say lawyer. Attorney in this sense is the person who is empowered to act on behalf of the person. So if I have named an enduring a power of attorney, or I've created an enduring power of attorney, that means that it will survive my inability to make decisions for myself. So that's where an enduring power of attorney is much more common. We sometimes most likely are going to be dropping that term and saying enduring. We're just going to say a power of attorney. But technically, just a power of attorney, if it doesn't mention that it's to survive an incapacitation or an incompetency, then it should stop. But most, especially again, if you go to see a lawyer or a law firm, then they're going to create it in that way. But there is, again, no requirement to have it. It simply needs to be in writing and needs to be witnessed by someone, a witness that is not, again, the attorney or the spouse of the attorney. As long as it's anyone else, it's okay. That said, it's, this document is going to be used most likely by banks, by other financial institutions or service providers. And if they don't like it, well, you can yell at them or say, hey, that's not fair. I saw on this webinar, I look at the Power of Attorneys Act. The bank manager doesn't care. They're just going to say, we're not accepting it. So that's where sometimes reality, kind of conflicts with what the law is written. If the bank, for example, refuses to recognize the power of attorney, then that's the end of it. You can go to court, you can try to force the issue, of course, but there's no magic way to force them other than to go to a higher up, because what is a bank? A business. And that's really what people tend to forget, is a bank is simply a business. And if they say, we're not taking this chance, this risk of liability, where we may give someone on this poorly written document and we don't know, so we'll say no, we don't agree to recognize it. So that's where it gets a bit tricky, and that's where a power of attorney perhaps is a document that is perhaps better done with a lawyer, because those fancy terms are going to be more something what the bank or other businesses may like to read. Whereas a personal directive, well, you're dealing with who? You're dealing with RNs, doctors, social workers, members of the hospital team. They're not really going to be too concerned about the wording, and they will understand what a template that government would provide, or that we at LISNS would provide. That's okay, and that's usually going to be something more digestible to them. So I just wanted to briefly touch on, again, I don't want to get into too much the issues surrounding estate issues, but medical assistance in dying is an important one just to touch upon, to say that it is a situation where a person has to decide for themselves. So it is not a situation where you can appoint someone to speak on your behalf. You must have capacity. So the idea is that there's going to be a whole assessment and eligibility criteria that a doctor or a nurse practitioner will need to go through in order to determine whether a person is eligible. But this is not something that can be given to someone else. You cannot give a substitute decision maker the ability to consent to medical assistance in dying. The doctor and their hospital team will have to review whether the patient has a grievous and irremediable medical condition. And again, it doesn't require, though, of course, the spouse. There's a case that ran through the courts last year dealing with that, where the spouse that wished to receive medical assistance in dying had received permission and became eligible, where the spouse, his wife, did not believe that he should receive it, and unfortunately it went through the courts and it was litigated through courts. But that's just to say that it's something that is there, and it is new, and something that people will have to, of course, decide for themselves, but the courts will have to tackle at some point. So maybe there may be questions that you may get in that context. So I just at least want to include a slide. Most likely would have more information down the road in another webinar. Again, because it's new, the Human Organ and Tissue Donation Act, a lot of confusion surrounding that. This is just information that I didn't take from the Act itself. I took it from, because that would have been a bit more confusing, I suppose, but I took from the government's website that deals with trying to communicate this to the public. So they say at the end here, whatever you choose, let the people in your life know your decision to ensure it is honored. that has always been the case. And I think that that's something that may have been lost with the implementation of the changes to the Act, is that it doesn't change the fact that the decision is always to the family member. It is not my decision as the deceased person, because I'm no longer able to make decisions for myself. I have essentially become incompetent, incapacitated obviously, because I've died, but my body's still alive. So I'm brain dead, but my body's still being sustained, because that's the only way a tissue donation can take place. So I'm still alive, and I'm still able to, basically the treatment is going to have to be decided upon by a family member. So if I had communicated that I wanted to be a human organ and tissue donor, that doesn't mean that my spouse needs to consent to that. She can say, no, I don't agree with it, and I'm not going to respect his wishes. And that's fine. That's their decision from a legal standpoint. The only thing that it changed is that the assumption was before that they were not referred to the organ and tissue donation program to determine whether they were good candidates. So only the patients that were registered donors would be reviewed by the clinical team to determine whether they would be eligible donors, and then to then turn to the family and say, okay, well, this person had indicated that they wanted to be an organ donor. Are you consenting on their behalf? So that step was how it used to be. Now what it is this person did not opt out of the donation program. So do you want to consent to the donation program? So that's the difference, is where the conversation is led. But of course, the confusion for people is, well, what happens if you die and no one is there? Well, that's the situation where under the old legislation, it would mean you're not going to be giving organ donations. But under the new law, well, the assumption would be that they could proceed if they take all reasonable steps to try to locate, and there is no one there and they can't get consent. Well, who does the consent fall to? To the hospital. So ultimately they would decide by government. So, but there's always the ability, of course, to opt out. So that's the changes with the Human Organ and Tissue Donation Act. All right, so that kind of closes that part of the kind of first part of the presentation that was more focused on things when a person is still alive. But this is more in terms of what happens now when a person passes away. Well, the first step, again, in kind of relation with the power of attorney, personal directive, of these documents that we refer to, or I refer to, is that similarly, the will does not need to be created by a lawyer. It may be beneficial, again, in my example of getting a plumber around my house. I don't know how plumbing works in my house. I'm probably going to muck things up, but I don't need to have a lawyer do that. So the same way that I may write a will thinking, well, this makes sense to me. Well, maybe not. Maybe I forgot about things. Maybe I gave my 2020 car thinking that meant my car, but actually meant my specific car. And then I lose it in 5 years, or I buy a new one in 5 years, and then I die. Well, do they get my car? No. Well, these are just little things that may happen when you're writing the will, but you're not really thinking about specific gifts versus general gifts, whether something should be general or something more specific. There can be these types of issues. So sure, it can be beneficial to have a lawyer prepare a will, but there's no requirement. Again, you can have two ways basically to prepare a will, whether it's done by a lawyer or not. The first one is you have it typed up, and then you sign it, and then you sign it by two people that witness your signature. So all three of you, so there's three people in a room, minimum. So I sign as the testator, as the person who's writing my will. A testament is kind of the French word for a will, so last will and testament, so we call it a testator. So I'm the testator. So if I write my will or type it up and I sign it, I date it, and I sign it in front of two people, and those two people will also sign, and those witnesses are, or should not be, and I say should, and not be the beneficiaries to a will. Now, the reason I say should is because it won't invalidate the will. It doesn't make that the will is going to be invalid, but it will invalidate the gift to the beneficiary. So if I have my sister act as my witness and I gave my sister a gift in my will, well, she's not getting that gift because she cannot benefit. A witness cannot benefit from the will that they're signing as a witness. So you just get anyone else, it doesn't matter who it is. And most likely, if you're going to a law firm to do that will, the lawyer is most likely not going to be the witness. They will most likely get one of their assistants or paralegals to sign as a witness because they don't want to necessarily have to be brought into court and have to deal with it. Depends on the practice, but ultimately, even when you go to see a lawyer, those witnesses are most likely going to be unknown to you in a sense, but they're most likely not going to be your lawyers. So it doesn't matter who it is. It could be a friendly neighbor. It could be a friend that you're not going to be giving anything to. It doesn't matter as long as they're over the age of majority and they can confirm, yes, I did see that person sign, then it's good. So that's the first way ultimately, is to just have it typed up, sign it at the end. It says that, it shall be signed at the end or foot thereof, but just sign at the end of the document. And it's, all the witnesses are signing in the same room. Again, you shouldn't be having someone else, in another room and say, hey, come on over, it's your turn to sign. No, all three of you should be signing and looking at each other sign. That's important because there have been occasions where people have lost their will or it wasn't seen as legal because, not everyone was in the room. It was a nurse that was out in the hallway that they grabbed and said, here, just sign, right? So it's important to get everyone in the same room and just sign together. The other way is that you just sign it, you just handwrite it. So that's called a holograph will. It doesn't, it's not necessarily the easiest way to have it presented to banks and whoever else to recognize it, but the court certainly will accept it. So the idea is that you can have your will can just be handwritten and signed, and it does not require a witness, because as long as it's in your own handwriting, then it's okay. What will happen is when the will is sent to the probate court, if it needs to go to the probate court, then someone who knows your handwriting is going to have to sign a sworn document, which we call an affidavit. So a person will have to say, yes, I know this person. I've seen this person's handwriting multiple times, and I can confirm, yes, that this was in fact handwritten by them. So instead of having a witness basically see the testator sign, they would have a person sign an affidavit saying, yes, this is in fact their handwriting. I can confirm that this is their handwriting. So when it comes to the witness, in terms of that, about 20 years ago, they changed the Probate Act, which is our law dealing with probate court matters, to allow a witness of a will to sign an affidavit. So an affidavit, for those of you that don't know, is a sworn document. It replaces a person taking the witness stand and saying, that they saying under oath of what it is that they're signing to. So if you go in to the to a lawyer's office, then they can put you under oath and say, okay, you are swearing to this the same way as if you went into court and swore under oath from the witness stand. So that's called an affidavit of execution, and that is something that will prevent perhaps the witness from having to be dragged into court in the event that they do actually have to go to court. So the witness can sign an affidavit, and that affidavit can simply be kept with the will, as long as it's signed after the will was signed, of course, right? Because they have to swear an oath to say, yeah, I did actually see this person sign, then they're good. So then they would be able to file that with the court and not be bothered down the road. But of course, if it cannot be, then there is no affidavit or cannot be found, then the person seeking to get the court's approval to be named the personal representative of the estate, the executor, in other words, will typically need to contact one of the witnesses and have that person come in. And it's also important that to know that most affidavits are going to be able to be sworn in front of a commissioner of oath, meaning anyone who is a named commissioner of oath would be able to take the person's oath and say, yeah, I am, I'm putting you under oath. You're good to go. You're going to, this document is properly sworn. But for an affidavit of execution, it requires either that it would be a lawyer, because every lawyer is a commissioner of oath, but not every commissioner of oath is a lawyer. So it requires a lawyer to be the person signing the affidavit, or the registrar of the court, of the probate court, or the deputy registrar. So it's a bit more of a heightened formality, if you will. It doesn't, because there are some members of parliament, so MPs, MLAs, members of the Legislative Assembly, police officers, government workers that are appointed as commissioner of oaths by the province, but they would not be able to sign as an affidavit of execution. It would really require a lawyer or someone from the probate court. All right. So in terms of the when it comes to the executor, so an executor is the personal representative that you name in your will. So it is someone that you say, I want this person to be the person managing my affairs when I die, to take responsibility. You don't need to seek the person's permission. You simply need to name them and choose them ultimately. So you should choose wisely, of course, but you are choosing the person. If you choose someone and you expect that, you will, that if they're a youth or a child at the time, and you're thinking, well, my child's 16, I'll name her my executor, but then you die before she turns 19, so pass away in a year or two. Well, then that person is not yet 19, and therefore they cannot be the executor until they're an adult. And the age of majority in Nova Scotia is 19, other provinces is 18, but these laws are provincial. So it's important to know it doesn't matter what happens in other provinces. It certainly doesn't matter what happens in other countries, but really you can't necessarily compare other provinces to our own. So our age of majority is 19. That means the executor can only be an adult who has reached that age. So what happens if the person, the primary executor, is not 19? Well, if there's an alternate, right, and that's an example of, whether you have legal advice or not, could be a benefit. But the idea is that you would hope to write an alternate, to name an alternate. So in the event of, and that could be because you're naming a child at the time, someone under the age of majority, or I could be naming my spouse. I've always believed that my spouse is going to survive me. I'm pretty confident, even though we're the same age. I'm just like, well, she's obviously going to survive me. But what happens if she doesn't, right? And I've now created a will. I've named her as the executor, and then she dies, but I'm in a long-term care facility. I no longer have capacity, so I can't change my will. So it's good to have an alternate. Or maybe I've named my wife, and my wife is in no position to take that responsibility because either she doesn't want to or she has lost capacity herself. So it's always a good idea to have an alternate. And in the event that there's someone who is not 19, then the court can issue the temporary grant to someone else, either the alternate or the guardian of the child. So, for example, parent of the child. And then once the child turns 19, they can become the executor. All right. So I just wanted to
Nicholas?
touch upon.
Sorry to interrupt. There was a question in the chat a few minutes ago about, I believe, the same situation that you've pretty much described, but just to confirm, this woman's aunt has since passed away after being named as an executor, and she was wondering if her family becomes one of the executors afterwards, or is there going to be an application for a temporary grant?
Yeah, so I see that question. So thank you, Kelly. So what happens is that an executor is the term. So I will use the term executor and personal representative interchangeably, or you may have noticed that. What happens is a personal representative is the proper term to name, to identify the person who is managing the person's estate when the person died. So if I have a will, then I name an executor. But if either I don't have a will or the executor cannot act for whatever reason, then the court must appoint someone, and that person will be called an administrator. And that requires a court application to the probate court. So it's typically going to be in order of priority. You can think of, and I'll give there's a slide that will give the specific entitlement to administration, to who can actually apply for administration. But it's very similar to what we saw previously with the Hospitals Act: surviving spouse, surviving adult children, surviving parents, surviving grandparents, et cetera, right? To keep going down the list. So that's what would typically happen. If I name a person to be the the executor of my estate in my will, well, I do have a will. I have named the executor. Maybe the executor cannot or does not wish to act. So the person, the family member, can apply to the probate court, and with the will attached to their application, to say, here's the reason why I'm filing this application, either the death certificate of the person who's passed away, or the letter from a doctor saying this person has lost capacity and therefore is not able to act, right? They lack capacity, or a renunciation. They've signed off on, they've renounced, they've said, I don't want to be the executor for whatever reason. No need to justify. It's not an explanation that is very detailed. It's just, I don't want to be the executor. So at that point, the court will determine who they should appoint, whether it should be the applicant or if there's someone else. So it's not that they would necessarily become the executors, but they would ultimately be the administrators. An administrator and an executor are all the same, but in name. They are both personal representatives. It's just we recognize an executor as someone who's been appointed through the will, and an administrator who has been appointed by the court. So just to distinguish the two. So I hope that answered that question. Please feel free to write in the chat and or to let Kelly know if you need more clarification on that. But there will be more information about intestate or a person administration, that kind of stuff in the next few slides here. But these are just some FAQs that I often get, and I think that some people will sometimes have themselves, where they may ask, okay, well, I have a will, where do I register my will? Well, there is no way to register your will with the courts. There's no requirement for the court to accept your will and to kind of put it in for safekeeping. Oftentimes people may place it at a bank, right? But that is ultimately just another private business, as I mentioned before, in a safe deposit box, or they can put it in somewhere secure in their own home. They may give it to someone else, whatever. But that's their decision as to where they wish to place their will. The law firm doesn't have a legal requirement to keep the will in their possession. I mean, there are certain practice procedures that law firms should keep their files for a period of time. Usually it's not to be sued or to have to defend themselves under an allegation of improper practice, but they may or may not have a copy of the will. So that, ultimately there is no place to register your will or to obtain a copy of the will. What will happen is you can call the Barrister Society or contact them, the regulators of lawyers, which we call the Nova Scotia Barrister Society. You can call them and say, hey, I'm looking for my deceased person's will, and I'm not sure that I contacted the law firm, they don't seem to have it, or I don't know if they had one. They can send out this type of email to all the lawyers in the province, say, hey, we have a missing will. It's usually not in a massive email. It's usually in this type of monthly publication that they send out to members of the bar to say, okay, well, this is what's happening in the province. And hey, by the way, do you know Mary Smith's will is missing? Do you have a copy of it? Something. So the other question sometimes people get confused with is, well, I wasn't invited to the reading of the will, or who do I need to invite? Well, there is no formal reading of the will as it's portrayed on TV or in American media. It's something that maybe people do, but there is certainly no legal requirement to do this and to share the will with other people. And it shouldn't be, it's a bit odd to say, but there's also no requirement for a person who is alive to share their will with members of their family. I received a call once where a daughter was seeking a copy of the will of their mother, and I asked them, when did your mother pass away or something like that, and said, oh no, she's still alive. It's like, well, that's not, you don't have the ability to get a copy of the will. First and foremost, it's irrelevant. Why would you? Because the will can be changed at any point in time if the person is still competent. But second, it has no legal effect until the person dies. So when we were talking about the power of attorney or powers of attorney in that document, that names the attorney. But if a person is incompetent, is in a long-term care facility, and a child of the person says, well, I have the person's will, I'm the executor, shouldn't I be able to act on that? No, because the person is still alive, and therefore the will has no force and effect. It has no legal authority. So the next question will end up being, well, how do I get a copy of the will then? Well, if the person has passed away, then it's really calling the probate court, or at least finding out whether someone has initiated a probate court process. And it's important to know that court, we have something called an open principle when it comes to court. In other words, if you're interested or curious about what's going on at the Justice Center, then technically, if we forget about COVID for a minute, if you just go into, the provincial court because you want to listen and see what's going on, then you're allowed to do that. You don't have to seek permission. Other than family court, that will be a bit more closed off for protecting youth. Any other type of court matter, well, you're technically supposed to just be able to walk in and listen to what's going on. So when a person dies and the will is sent to probate court, then you can call and ask, hey, do you have a copy of John Smith's will? And if they say yes, then they'll send it to you. You don't have to prove that you're entitled to it. We are all entitled to it, because how do you prove a lifelong friendship with someone? You can't. I can prove I'm the child of a deceased parent because, well, they're on my birth certificate, most likely. I can prove that I'm the spouse of a deceased spouse because of a marriage certificate, potentially. But how do I prove that my best friend that has left me everything in their will, that I am entitled to get a copy of it? So we kind of think about it that way, is okay, well, that's why ultimately the court will just give a copy of the will if it's filed with them, because the probate court has been triggered. Then they will send it out to any interested person. So that's one way to get it. But there's no legal responsibility on the personal representative, whether it's the executor or administrator, to send the will in its entirety to the beneficiaries. It's simply, there is notifications of, hey, you received something in the will. There's a requirement there, but not to open up the books and share with everyone. Once you file it with the probate court, though, then it becomes open to anyone who's interested. So, and then the question of, do I have to be personal representative if I'm the executor in the will? Again, kind of already touched upon that, but no, there's no requirement to be the personal representative. Oh, I kind of skipped over the other question, which is, am I responsible for paying for the deceased person's debts? You're never responsible for another person's debts, whether that person is alive or dead. And I'll give an example. My wife goes out and gets a line of credit and she signs, and I have no idea about it, or even if I did, but I did not sign it, my name is nowhere on those documents. I am not personally responsible for it. If she defaults on that payment, they cannot come after me. They cannot sue me. I am not liable for that debt. Same thing applies when a person dies. Our debt does survive our death, but that binds our estate, which is us, in other words. It doesn't transfer over personally to anyone else, whether it's a family member, a parent, child, a spouse, the personal representative of the estate. It doesn't become their personal responsibility. It is the estate's responsibility to pay the debts. And that debt needs to be paid before beneficiaries receive it. So I think that's maybe where people get that a bit confused, is thinking, well, you know, there's $10,000 in this bank account and it's supposed to go to me, but the bank is taking it. Well, yeah, but it's not yours, it's the estate. It has to be given to the estate has the $10,000. They'll have to divvy it up. And if there's money left over, then you'll be able to take it. But if the estate is insolvent, if the person has $5,000 in their bank account and they have a $10,000 debt, well, the creditor gets $5,000, and that's the risk of lending money to people. You don't get your money back sometimes. But that does not mean that the bank or the lender can go after family members to seek the remaining funds. And that includes the Canada Revenue Agency. Some people, and I understand there's a moral or a emotional feeling, especially for a parent or a child, and say, well, I want this person to be cleared of debt. I don't want them to have this debt after they've passed away. That's fine. That's a personal and an emotional decision which no one should interfere with, but it doesn't require, it's not a legal requirement for that person to pay that person's debts. But of course, that is going to be tricky when you're dealing with assets that are jointly held, right? So if I have a joint bank account, or more often than not, a house with a mortgage, I cannot say, well, it's my house, I get to keep it. Yeah, but there's a mortgage on it. And if the person has passed away and the mortgage is still, you can't absolve yourself or protect the property necessarily from the reach of the creditors from the mortgage lender. So that relationship is still there. So maybe there's that connection with joint assets. That's a trickier part, and that's where you have to be really on a case-by-case basis to figure out whether it is actually something that the creditors may be able to collect. But that's because the person's name was on it and your name was on it. But if your name was not on any debt, then you're not responsible. So the final question is, do I need to go to probate court? And that will lead into, more of actually going to probate court, because it's important to know that there's never a requirement per se for a person to go to probate court. Some people assume that everyone who dies, that their matter must go to probate court, but that's not correct. The idea is that there are times where you may need to. The most common one is going to be a situation where you have real property. And what I mean by real property is real estate. If you have a house, you have land, then that land is recorded at the Registry of Deeds. So your title, your ownership is recorded in the hands of the government. Some people may not realize this, but how our system essentially evolved over, when Canada was created, and how we took our laws from the UK. The land is owned by government. In other words, the land is owned by the Queen. The Queen owns all, and basically we have deeds. We have entitlements too, and we have essentially all rights too. We can do anything we want with our land that we own, but it is government that controls it. So that's why when you're dealing with land, with real property, with real estate, then you will always need a court order, which is called a grant, in order to sell or transfer that land. So if you just want to live there, and that's another important point, there's a big difference or there's a distinction, I should say, between ownership and possession. Think of a tenant in an apartment. Well, they don't own it, but they certainly have a lot of rights, and certainly more so than the actual owner, perhaps. So even if I may not be the legal owner of my parents' home, but I've lived here for 10, 15 years, whatever, dad dies, he's still on the title. Well, I can continue to live here forever. As long as the taxes are paid, the municipality's not going to care. And as long as there's no mortgage, because of course, mortgage company's not going to be happy if they hear that the deceased, the person who's on the mortgage has died. And that means that it may be difficult for them to require their money. So they most likely will need that money. But if there's no mortgage and I'm just living in my parents' home, I don't need to go to court because I'm not looking to sell my house, right? If I'm looking to sell the house, if I'm looking to transfer it into my name, then it becomes a situation where I need to go to probate court. And this will often happen with low-income families where the person does not have the money to go to probate court and is living within their parents' home, their deceased parents' home, whomever, but we'll just give the example of the deceased person's home, deceased parents' home, then they apply for some form of grant to renovate or to improve their home. Well, government requires, in order to get that grant, that money, that subsidy, to have the title in their name. So that would require them to go to court, and that will trigger the process. But that, again, is always about government giving money or you wishing to sell the land or transfer the land into your name. That's where the court will come in. So what I try to explain to people is that the court is there for you. It's there as a resource. They are not, the probate court as a civil court, the probate court is not going to impose themselves without being spurred on by someone. Someone has to apply to the probate court, but there's no requirement from them, from the courts, to get them involved. So if you need a court order, then you can apply to probate. And the example is the land registration office to transfer land in order to sell it. The other example is, banks, as I've discussed before, or I mentioned before, banks are private businesses. And if a bank or any other organization holds assets in the name of the deceased, then they may require you to get a grant so that that money can be given to you or to whomever else, because that grant is going to be proof for them that it is that you're the personal representative. So even if you have a will and you go to the bank and you're like, hey, bank, here's my deceased person's will, give me access to that person's bank account, most likely than not, they're going to accept that. But BMO is not TD, which is not RBC, which is not the credit union. They're all businesses, and they may look at things differently. And Toronto may do things differently than Vancouver, than Halifax, than Shelburne. So the idea is that if you go into a bank and they say, we don't recognize this document, then you will need to go to probate court in order to get a court order, because they're not accepting you, either because they don't accept the will, or more often than not, it's because you have a person who's died without a will. And I'll get to that. I just wanted to touch upon, some people will ask in terms of, I should say, sorry, before that, the question of transfer of land. If I own my land with my wife, as I do, I own a house with my wife, we're joint tenants. What that means is that we don't own the house 50-50. We own it 100%. We're co-owners of it. So we own it entirely between the two of us. I don't own a percentage, I own all of it. So if I go to the land registration office and I ask them, how am I holding the title? They'll say it's joint tenants. So that means if I die, or when I die, then my wife will be able to go to the land registration office with my proof of death, and they will remove my name from the title, because it has not affected, it's not a transfer, it's not a sale. She is on title and she owns 100% of it. She's just removing my name from it. It doesn't affect any ownership rights. She's always been the 100% owner. So that's different though from tenants in common, where if I own a cottage with my sister, I may own 50% of it or a quarter of it. Well, that is different. There is no right of survivorship out of tenants in common. But most people, when you're dealing with property, you're thinking about spouses that own property together. They're most likely going to hold it as joint tenants. Most of you may not have known that term, and you may be married or living with someone in a common law relationship and co-own the property. That's how you own it. You own it as joint tenants because that's the default. It's a right of survivorship. So that's the situation where you would not require a court order, even though you own land. But if you do not own the land or your name is not on it, then you'll need a court order. So in order to deal with the court, there's always going to be fees. So this will give you, I just put a link to the probate court fees. We call them probate taxes in Nova Scotia when we're dealing with a percentage that is owed for opening up an estate, but other provinces will call them probate fees. But these courts of probate taxes is basically to say, okay, well, how much money must you put in order to open up the estate? So it goes by brackets, and then after $100,000, it'll go by percentage, or by every bracket of $1,000 anyway. So that's the fee that needs to be paid when you start the process. And then the another useful link is the actual forms. So these forms are all available on the court's website. I won't go through them, but ultimately they're there. I put a link because although the court's website is very useful, it can be difficult to navigate if you're not sure where to get the information. So that's where the forms are. You can always call the probate court and they will gladly send you the forms by email or by paper, so that you're able to get it. And I already put a link to this, but it's the or actually, well, these are the forms and regulations, I guess. But yeah, it's just kind of the regulations to kind of help the different forms that are available and the different ways to deal with the court. So just for ease of reference. So Intestate Succession Act. So what happens is that when you're dealing with an estate and you have a will, then that's one process. But if you don't have a will, meaning a testament, then it's intestate. So the person is either testate, meaning there is a will, a testament, or the person is, or the estate is intestate. So what happens in a situation where a person has died without a will? So there's a lot of misinformation about this. And again, this will fall to other provinces, but also just, Johnny said this and they saw this on TV and this movie told us about something. So we're all influenced by different misinformation that may reach us. But the law in Nova Scotia is quite simple. It's and it may not make sense for everyone, but it is what we have. So we have to kind of go with what it is. So the Intestate Succession Act will basically say that when a person dies without a will, then the first beneficiary is the surviving spouse. So the surviving spouse receives a minimum of $50,000. So if the estate is worth less than $50,000, then the surviving spouse gets everything. If there is more than $50,000, then it becomes divided between the surviving spouse and children. Now, they refer to the word issue, which I would only really traditionally hear that when talking about lineages of heredity under with the royals or things, because we're talking about a lineage from parent to child, parent to child, parent to child. So the idea is that maybe you have a child, but that child has predeceased you, but your child now has their grandchild or your grandchild. So it will go down that line. So when we're dealing with surviving spouse and child, it's interchangeable with the grandchild. It goes down the lineage, so that even though if you as a grandchild have lost your parent, you don't lose your inheritance. You get your parents' inheritance. It goes through that line, through that lineage of succession. So in any event, the idea is that the surviving spouse gets 50,000, the first 50,000, then everything else is kind of divided in the way that it's described here in the Intestate Succession Act. So after that, well, what happens if there is no surviving spouse and there are no children? Either there never was or they've all predeceased and the succession has ended. Well, then it goes to issues surrounding, okay, well, are there surviving parents? And if there are surviving parents, then they receive it in equal share if they're both alive. If there are no parents, there are no children, there are no spouse, then you're dealing with siblings. And then you're dealing with, again, the issue of the inheritance. So if my father has died and his brother has died, and I will receive my father's inheritance. So again, that lineage. But the idea is through siblings. That's the next in line, and then the nieces and nephews, and on it goes. So that's the idea of where it will turn to the court to say, okay, this is what the government has provided us in terms of the order of priority. And that distribution of next of kin, well, that will continue if they cannot find next of kins. Well, that's where the old, random spam email that we would occasionally get, when emails first started to become popular. Well, your long lost, cousin or 3 times removed has died and you are a beneficiary. That is technically possible. It's under that distribution under an Intestate Succession Act, where they would need to find the person to inherit. So it doesn't go as maybe a fear of some, it doesn't go to government. There's a responsibility to eventually distribute it to surviving members by level of kinship. So the section of adultery, the reason I've included that is the Intestate Succession Act is an old law, and it's old, but it's still valid. And this is a law that government has created, the Legislative Assembly, the provincial government, and courts are simply there to apply the law. They are there to interpret the law, but they're not there to change the law. They are not, unless it's unconstitutional, and of course at that point they can find a law to be unconstitutional and therefore should have no longer an enforcement effect. But the law, as it was written and it still continues to be, is one of the scenarios where if a person asks you, is a married spouse and a common law spouse, are they identical? Are they the same in the eyes of the law? Well, the answer would be no, because when we're talking about in the eyes of the capital L law, so all laws of the province or the country, then no, there are laws that distinguish and differentiate between a married spouse and a common law partner or common law spouse. So there are laws that are specific in defining what a spouse is, and usually the law will specify what they mean by a spouse. So for example, the Pension Benefits Act will specify that a spouse is either someone who has been who is legally married or who has been living together in a conjugal relationship for at least 12 months or a year. So that's common law. And that's where sometimes people get confused about, well, what is like in my common law? I've been together for 6 months, a year, 2 years. Well, again, it depends on the law. The Parenting and Support Act, which is a law that deals with spouse support, for example, that defines a common law relationship as living together for 2 years. So again, it depends on the law, and there is no uniform definition of a common law partnership. But this law specifically refers to husband and wife. And that means that the legislator was specific in their language, meaning a common law spouse is not entitled as a spouse under the Intestate Succession Act. So if you were living with your spouse for, doesn't matter, 5 years, 25 years, 50 years, it doesn't matter. If you're not married and the person has died and they don't have a will, then you are not the surviving spouse under the Intestate Succession Act. You will be the surviving spouse under the survivor benefit of CPP. You will be the survivor for Canada Pension Plan if there was something to be paid, but you will not be the spouse under the Intestate Succession Act. So the way that the language is written here in terms of adultery is that they say if a wife has left her husband is living in adultery at the time of his death, she shall take no part of her husband's estate under this act. In other words, if I am in a common law relationship, or sorry, if I'm married, I should say, I'm married to my wife. If I and she separate and she dies, what is my relationship status? Not what is her relationship status at the time of her death. That's irrelevant. It's what is my relationship status as the surviving spouse. So if I'm living with someone, meaning I'm in an adulterous relationship, which is a term we would never use nowadays, but again, the act is archaic a bit, we'll say, in their language. So I am technically in adultery, even though I may be separated from my spouse for 20 years. We just never gotten around to get a divorce. And I've been living with my new common law spouse for 20 plus years, and we have kids together and whatever else. Well, then I don't get a share. But it's not because we're no longer together. It's because I'm living with someone. But let's flip things around. And I'm the one who has died. And I'm the one who's been living with my common law partner for 20 plus years, got married, never got divorced from the first wife, now been living for 20 plus years, kids, etc., lived my life, died. Well, what is happening with my married spouse? Is she with someone? If she's single, she's the surviving spouse. She is the person who's the first person to receive the money under the Intestate Succession Act. So, and this has been challenged recently, like in the past, 2020 was the most recent case. If I haven't looked recently, but I don't think it's anything new has come out, but the court was very explicit. That's what the Intestate Succession Act says. And what the court does when they say that is they just pass it along to the legislator and say, look, the legislator knows that what this is. They've decided, so politicians have decided not to change this. So I understand where people may feel that is, unusual or unacceptable in their own personal situation if they were faced with that. But it's how the law is written, and therefore the court can simply go by how it is. So whenever a person says, well, common law and married is identical, well, okay, but this is a very clear example where no, there is a big difference between being legally married and being in a common law relationship. So under the Probate Act, so again, in terms of dealing with the probate court, there is no requirement to go to the probate court, but they do have the power to issue those grants, that court order, to assist a person in being able to manage the person's estate. So that's where the court, upon application, can issue the grant. So that's what we'll call a grant. Other provinces will call it a letter of probate or a letter of administration. Nova Scotia, we call it the grant of probate or a grant of administration. The courts give out grants for issues that are specific to this province, meaning the person is living in this province, and therefore they have the authority to issue the court order. But so in other words, if you live in Yarmouth, then you're dealing with the Yarmouth probate district. If you live in Halifax, it's the Halifax. If you're living out in Port Hawkesbury, it's Port Hawkesbury, et cetera, et cetera. But if you live in another province, like you moved to Moncton and you've been living there for years, it doesn't matter whether you were born and raised and spent 50 years in Nova Scotia. If the past 2 or 3 years you were living out in New Brunswick, well, this courts, they don't have any jurisdiction over this unless we're dealing with property. And at that point, because property has to be dealt with by the province. So as I kind of alluded to in terms of the Crown owns all government, in other words, meaning the Queen, well, the authority to manage land is kind of given to the individual provinces. So the provinces have the authority to make decisions about land within their borders. Nova Scotia has no authority over land in New Brunswick. So if someone dies here and they own land in Nova Scotia, if someone dies in another province, but they own land in Nova Scotia, well then, for example, New Brunswick, in my example of Moncton, they die in Moncton, they go to probate court in Moncton, and they get all that they need to do. Well, that court has no authority over land out in, Chester. What will happen is that the Bridgewater Court, for example, will need to issue a grant to deal with that land. So that's usually the only time where maybe 2 courts get involved, but it has to go to the district where the person was living or where they own land. So in terms of the previous question that was asked a while ago in terms of the entitlement to the administration, and I kind of referred that it's similar to the issue surrounding the Hospitals Act. So the administration, entitlement to administration, remember that means a person has died without a will, or they've died with a will, but the executors are not able to act for whatever reason. So at that point, the court can issue the grant of administration. So who is entitled to receive the administration? Well, the first is the spouse and the children, if they live in the province. So it's going to be issues surrounding the province. So it's going to be, if you have a spouse or children that live in the province, then they will be able to apply for the administration. If not, then it goes to whoever else who lives in the province that would fall under the Intestate Act. So, siblings or grandparents or whoever, they would be, but if they're in the province, they would be next in line. And then the third would be the public trustee. To be honest, the government public trustee is not going to be too keen on having to take on this responsibility if they can avoid it. So you would typically need, if you don't fall within the first two categories and you maybe fall within the fourth, well, what you would need is to get the permission from the public trustee, basically them signing off, saying, yeah, we're not going to take over this, because they want to get paid. They're not going to, expend resources and not receive money. They have limited resources as it is, so they're not just going to take over anything that if they can avoid it. So anyway, but they are the third in line. The fourth, so government would be third in line. The fourth would be any other beneficiaries that live outside of the province. And then the fifth is creditors. So in other words, people that are owed money from the estate. So in the event that you do apply for the status of administrator, then you will need to be bonded, or what we will call to provide security. So we often see this more maybe in a criminal setting or out in the American media again, but security is basically as a way to ensure, to provide the court with the confidence that the administrator who's going to be named by the court is going to do their due diligence and make sure that in the event that they mismanage the estate, either by recklessness, negligence, or malfeasance, that they will be held accountable. So in order to do that, you will need to provide typically a security, so an amount, or to say that you can essentially be sued for up to 1.5 times the value of the estate. So you have in your name approximately 1.5 times the value of the estate. So a quick example, I have, or my father dies, he has an estate worth $100,000. He died without a will. $100,000 times 1.5 is 150,000. So if I want to be the administrator of the estate, I will need to provide some form of security to the court to say that I am insured, if you will, by $150,000. So whether that's a bond from a guarantee company or some form of personal bond, so kind of think of a surety or as someone who's kind of signing off saying, yeah, I'm gonna confirm that I can be sued as well. So just kind of building up the people that can be held responsible financially for it, or a letter from a financial institution to say, hey, this person has assets in excess of 150,000, for example. The security can be waived if you're the sole beneficiary. So think of surviving spouse. Well, they would not, if there is no one else, then you don't need to be protected from yourself. It's to protect other beneficiaries. But if you're going to be the sole heir, the sole person to benefit from the estate, then they're not going to ask for security or to be bonded. So this is just a kind of quick summary of, well, what do you do when you need to go to the probate court? Well, you just call them up and you get an appointment with them. And then in order to, come to the meeting prepared, well, then you would make sure that you have a copy of the will. I didn't mention what a codicil is. That's what that word is. Codicil is essentially something that is added to the will, but after the fact. So I write a will, and then you know what? I actually want to change this. But I don't want to rewrite my entire will. So I just write a codicil, which is something that is written after, but requires the same rules apply as a will would. So I would have to sign it in front of two witnesses. Doesn't matter who those witnesses are. They don't need to be the same witnesses of the original will, but of course they cannot be beneficiaries to the will. Anyway, the codicil would simply be signed by me in front of two witnesses and dated after the will. So that's what a codicil is. So the will and codicil, if they have it, they would provide that to the court. If it's intestate, of course, they wouldn't have that. The affidavit of execution, those are the witnesses that we, at least one person that can sign saying, yeah, I did see this person sign their will. Or if it was a holograph will, yeah, this person, this is their handwriting. So, if they hand wrote their will. And then they need to file a completed application for a grant of probate. Now, I gave the link for the probate court form. So that's where you find Form 9 or Form 8. Those are Word documents. They're relatively straightforward. It's all about a person's ability to read and to understand and manipulate a Word document, but they're built to be done by members of the public. So they're built to be modified. They're templates that the court provides. So I appreciate that people don't feel comfortable modifying a court form, but they are there to be modified. They're there as templates to insert, name of deceased, community where, I of Halifax Regional Municipality, born, whatever, you're just kind of providing the information where it's being asked. So it's pretty straightforward. And the registrar of probate can be there to assist to an extent. Although if it does become a problem, then, that's where you may need to hire a lawyer, but it's built so that you wouldn't have to, that you would be able to fill them out and complete them. They're really more asking for personal information about both yourself and the deceased that you should know more than a lawyer would anyway. And it's not really getting into the whole legal jargon or things like that. And so, of course, you would need proof of death, the death certificate. The death certificate is what the government issues, or the proof of death, which the funeral home would be able to provide. And then the security, if you need one. So those are the forms. And then if you have land, you'll need land registration forms, which again, government can give. So land registration forms are offered by the land registration office. So you need that. And then of course, the payment of the probate taxes. Some people may ask, well, do you need to pay them upfront? Yes, but it's based on an estimate, right? So it should not be your personal payment, but it's seen as an investment, right? So you open up the estate by getting the grant, and then you reimburse yourself by saying, okay, well, I had to pay $1,000 for the probate taxes, so I'm going to reimburse myself once I get the grant, once I get control over this person's financial affairs. So once they get the grant, or once you get the grant, whether it's a grant of probate or a grant of administration, whether you've been named as the executor or whether you've been appointed by the court as administrator, you do have to notify the beneficiaries. And this is where the requirement is triggered when I referred to the reading of the will a while back. Well, this is where the requirement under the court would be to notify the beneficiaries. So there are specific forms that you need to provide. Residuary, non-residuary, a residue is everything that you have at the end of your, after everyone has received the specific gifts, well, what is left? It's kind of like a catch-all, right? Kind of, well, what is the remaining amount that was not specifically identified, right? They didn't specify the new car that they had. It wasn't listed in the will. So what do we do with that? Well, that's a residual. It's something that is left over. So that is typically going to be listed as a catch-all final statement in your will. You would usually say, and all the rest and residue, well, it shall go to my child, right? And, Annabelle. So you just kind of, that's the residual beneficiary. So but that may be, Annabelle, my daughter, may be my residual beneficiary, but my sister, Renee, may not, right? She may be a non-residuary beneficiary. So again, it just depends on who is named and in what form they are to receive. But you're supposed to send it out 30 days afterwards and then kind of confirm that they've received it. And that notice simply needs to be sent out by mail. It's not a personal service issue. It just needs to send it out by regular mail to their address. So you need to notify, one of the requirements under the Probate Act is that you need to notify potential creditors. And the way that we do that is by publishing a notice of the person's death in the Royal Gazette, which is this publication that the province issues to notify members of the public of various things, companies that go bankrupt and things like that. But we'll also include a notice of the person's death and that the death is being taken to the probate court. So again, this is not something that, if a person dies, they don't have to put it in the Royal Gazette. That is only if you are triggering the court process and going through the probate court. So if that's the case, then you'll have to pay, I think it's about $40. I neglected to check before. It's approximately about $40 that you have to pay. And you send it out. It has to be published within the first, the 6 months. The next 6 months, it needs to be advertised. So that opens up a window for potential creditors to file a lawsuit or to file a claim against the estate. So when people refer to the statute of limitation, which is really more of a limitation of actions act in Nova Scotia. So this statute of limitation, usually you have 2 years, generally speaking, to sue someone for debt, for something. Well, this shrinks it to 6 months because the person has died and the estate is now open to litigation for the next 6 months. So it's advertised in the Royal Gazette, and then once that's done, then money can start being given to the beneficiaries. So the money can start being given out technically at any point in time. That said, it's not a good idea as a personal representative. You're going to expose yourself to liability if you give money that you're not supposed to give, and then all of a sudden someone comes out of the woodwork and says, "Hey, you owe me money," but you've given out all the money of the estate to beneficiaries. Well, how are they getting that money back, right? So the idea is that you're supposed to wait 6 months, and then you start divvying up the assets. You would still go to the bank, and you would still create a document surrounding, not a document, sorry, a bank account dealing with the estate, so that money can be put in, and maybe you transfer the property into your own name, so that you're able to sell it at some point in time. That's fine. All of these things, it's really about money. So as long as you control, and that's the whole point of the grant, is to be able to control the money, then that's fine. There's a quick question that I noticed about a living will, and it's a very good question, because it really goes more to that confusion surrounding language in what we use and what we hear in the news or in the media, or how our parents used to do things, or grandparents. A living will is, in my view, a misnomer. Is not something that makes sense from a legal standpoint, but I understand why it was traditionally used. Because a will is only in effect when a person dies. So a living will, well, what they were trying to say back in the day, and what people will still use occasionally, is they're trying to refer to the personal directive, the power of attorney, some form of guardianship, some form of representation order. So some form of document that allows a person to act in the person's capacity when that person has lost a competency or capacity. So a living will is, or used to traditionally refer to a power of attorney and a personal directive, or a medical consent as we used to have it. So what would end up happening is, it's kind of this whole, go to the lawyer and get all of it done. You get a will and you get a living will, right? Well, a living will was really a power of attorney, an enduring power of attorney to be more specific, and a personal directive, or what used to be a medical consent. So you'd be signing all these documents. You're doing all this estate planning with the lawyer or the law firm at the same time. So now you have a will and you have a living will. But that language shouldn't be used anymore. It's really more, it's better to be specific, because it does lead to confusion. So that's what a living will typically means when people use that. So just finally, a few last things in terms of the Probate Act, just to specify the power of the personal representative. people often say, well, don't they have the ability, or don't they have to consult with the beneficiaries? They're supposed to be acting in the best interest of the beneficiaries. True, but they are the legal representatives, so they're acting on their own. So they are supposed to act in the best interest of the estate, but they have the power to sell the property the same way as if it was their own property. They're to manage the property the same way it was their own property. Of course, always with what we call a fiduciary duty, or a duty of care. They have the utmost responsibility to ensure that whenever their interests diverge from the interests of the estate, it is always the interest of the estate that should be focused on. So they shouldn't benefit from it unnecessarily. But they don't need to consult with the representatives, because if my mother named me as her executor, and therefore I become her personal representative, she did not name my sister or sisters. I don't have to consult my 3 sisters. I don't need to get their permission because my mother appointed me, or the court appointed me. So I don't need their permission to act in a certain way. My responsibility to them is to give them their inheritance, to ensure that they receive their inheritance, not to kind of check on them and see. Of course, there are times where there needs to be a removal of the personal representative because of actions taken by the personal representative. So the court can remove the personal representative if it falls within these categories, but that would require a court application to say, I have problems with this person, with this personal representative. So if they're neglecting to administer the estate, they're wasting the estate, whatever, they become mentally incompetent, they've left, they've abandoned the province, and they have no idea where they are and just taken off. Multiple reasons that are kind of listed in the Probate Act. A beneficiary can apply to the court and say, remove the personal representative, whether it's the executor or the administrator. And the court will be able to have that authority to remove them. Finally, I think that was, so in terms of the accounting, so the court will need to receive an inventory, which is basically all within 3 months after the grant has been issued. So court gives me the grant. I'm now the personal representative of the estate. I now have 3 months to go in and round up all the assets and say, okay, what did my mom own? So I go through her banks, I go through her debts, I go through everything, and I figure out, and then I provide the court within 3 months an inventory. I can't do the inventory before I get the grant. So I have to get the grant, and then I can go and start, open up bank accounts and going over all of her things and taking possession, and then I must file within 3 months an inventory that will outline. And this inventory, of course, then becomes a matter of public record. So a beneficiary is like, well, I'm not getting any information from the executor or administrator. Okay, but call the court and get the inventory because it's open. You can get a copy of the inventory, right? So that's a simple step to just say, well, you know what? It's not worth dealing with the executor. I'm just going to go and call the court, and the court is the one that is overseeing, and the personal representative has a responsibility, not necessarily to the beneficiaries to keep them informed, but they're under the control of the probate court at that point. So they have to act in accordance with the Probate Act. An accounting is basically at the end of it. So the inventory is basically saying, okay, these are all the assets. The accounting is, where did all that money go? Where did all the assets go? So it's all kind of, so after 6 months, once the Royal Gazette publication has ended and that period of advertisement has completed, then beneficiaries can start receiving their money, and an accounting will need to be given to the court to say, well, where did all that go? And the accounting should be done within 18 months from the grant. So if we kind of look at the timeline, the grant is given, whenever that grant is, it could be 2 weeks after the person died, 2 years after the person died, it doesn't matter. Once the grant is given, that's the starting point. Once that starts, then there's an 18-month period that opens up, and the matter should be completed within that period of time. And if there is no accounting, if it's not completed, then there should be an explanation as to why. And that's where the personal representative, if they don't file it within 18 months, then a beneficiary can apply to the court, typically after the 18 months, to say, look, it's not about removing the executor or the administrator, but they haven't filed their account. They're delinquent, they're stalling. So after the 18 months, a beneficiary, can apply to the probate court to order the personal representative to pass the accounts. So to force them into action. But that requires, it's usually going to be in 18 months. So when a person says, well, how much time would it take to go through probate court? My easy answer is, well, between 6 months and 18 months, because that's usually what the law will say. 6 months because you have to wait for the Royal Gazette, 18 months because by then the court's going to be like, what's going on? But of course, the court themselves, they're not going to do it. And I should be very clear on that. The court is not going to contact the beneficiaries. The court is not going to contact the personal representatives. That is not the court's responsibility to interfere with the handling of the estate actively. It is that they will react to an application filed by a beneficiary. They will receive the paperwork once they are receiving the paperwork. But if they don't receive anything, then that they're just going to close the file at some point once it's been kicking around for 5 years or whatever. So the idea is that the probate court is not going to actively inquire, but they will respond to concerns over mismanagement or a beneficiary that has concerns. And then finally, once one of the things the person does have the ability to obtain, the personal representative, executor, administrator, has the ability to get up to 5% of the amount as a commission for their handling of the estate. And in the event that the personal representative has done everything and lo and behold, the estate is insolvent, meaning that there is more debt than there are assets, then they can apply to the court to declare that the estate is insolvent, and therefore that's kind of the end of it, that they wouldn't have any more liability. So that's the end of the presentation. I kind of went a bit further than I thought, but that's always kind of the case. I do encourage anyone to stay and ask any questions within the chat. If they have any questions, I'm happy to answer anything. But if not, this is the way that you can connect with us at LISNS through our phone line, the information line, toll free, the emails, and as I said, the content on our website. And just for everyone to know as well, the PowerPoint presentation, or at least the recording, will be sent out to those that are expecting or would like to read it for maybe to fall asleep one night. It can be useful. But as I said, certainly feel free to ask any more questions. I'm happy to stay a few minutes more to answer any questions that people may have. Okay. So with respect to a question about the delay in asking for a grant of probate, well, the idea is that typically you're going to be asking for the grant of probate because you need a court order. So it's never a requirement to get it. So the goal, if you are asking for a grant of probate, the assumption is that you have a will. So the whole point of having a will is that you would try to minimize the issues that a personal representative may have in handling the estate. So the goal would be not to have to go to probate court in order to get a grant issued, and just manage the estate as well as you can with the documents that are at your disposal. But of course, if comes to be that you need a grant, then you can file for one. But when it comes to what may be usual, I would say that, and I may not have been as clear on this, so I appreciate the chance to kind of specify that the beneficiaries or anyone who is interested in the estate, who has an interest in the estate or a potential interest in the estate, can apply to the probate court and force the person, the executor, to go to probate court. So it's oftentimes a situation of, if you don't have problems, right, with beneficiaries, then the court is not going to give you problems. But if you have someone who is like, look, I want you to go to probate court, and if you don't, I'm going to go to court and force you to go to probate court, then that's the option that is available to the person. So if I'm managing my family member's estate and we're all on the same page and everyone's happy and no one's, no predators are knocking down our door, no one's trying to force anything, then I don't need to go to probate court. But of course, if I have a sibling, for example, who's like, look, Nicholas, you need to do this. I want my money. Why aren't you going to probate court? Then the easy answer for my sister, as an example, would just be to go to probate court and say, hey, either renounce Nicholas, right? Nicholas, renounce as executor, or file for the grant. So it's more of a personal question at that point, because it is such a case-by-case basis. There are multiple reasons why a person may not wish to go to probate court. There's money involved. There's potential reopening of assets, and exposing it to creditors, that kind of stuff. So there's multitudes of reasons why a person may delay. But at the end of the day, if someone is concerned, then someone can file an application to probate to force the issue if they are concerned that there's mismanagement. So we'll keep the chat open for maybe another 2 or 3 minutes. So if anyone has any remaining questions, and I appreciate, if someone has a personal question about the presentation or just a personal question in general, and they would prefer to send me an email, as I said, you can send it to questions, but you certainly can send it to my own email. That's part of the slide deck that will be sent out. So certainly feel free to share your question today. Or to ask it later on. That's right, Kelly. Thank you. It's Nicholas@legalinfo.org. Okay, well, thanks everyone for joining us, and I certainly, as I said, encourage you all to send an email to that put it in, and just as Kelly is mentioning, we'll send out a feedback. We always like to receive good and bad feedback, so it helps us to change what doesn't work, and hopefully sends it or provides us also tools to receive funding from other government or other agencies to continue these types. And our goal is to be able to continue this in 2022. And we will be sending that out shortly. So on other topics that may be of interest. So certainly encourage you all to check and participate in any other future webinars. So thanks everyone for joining us.